We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy.
The state is saying is, oh, and then he's going to get Mr. Williams, personal lawyer for Mr. Copeland. That's not what it says. If that type of evidence comes in court, we are all in trouble, because that's what we want people to do. We want people to get lawyers.
Days 98 and 99 of the Young Thug YSL RICO trial were interesting. District Attorney Hilton and defense lawyers debate over Woody interrogation footage being shown to the jury. Then Brian Steele objects to a jail call between Thug and Woody where Thug offers his lawyer. Towards the end of this video, you'll see Brian Steele objecting to this portion of the jail call. The state wants this in because it shows that Thug, the big mob boss, is offering one of his co-conspirators a lawyer. I just want to see real hard evidence like DNA, phone tracking, ballistics. I swear a lot of this trial ends up being just jail calls, snitching, and a lot of hearsay, but hit subscribe. Here we go. First look at Thug on day 98. Light blue shirt on, doesn't need to wear a suit or anything because the jury's not in the room, obviously.
And whether Mr. Williams bought the gun from D. My position is that those sections contain testimonial statements that are not relevant. They can contain some hearsay, and they contain statements from the witness that is simply his opinion.
Not rumors, but from his personal knowledge about the fact that Quindarius Zachary is purchasing guns on behalf of members of YSL.
Can she turn her damn microphone on so we can hear this shit, man?
Was a straw purchaser for a number of guns that were recovered by YSL members. Specifically, the one gun that Mr. Copeland has in his possession, the reason for the arrest that brought him into this interview was a gun that Mr. Quindarius Zachary purchased on his behalf.
So this is Woody snitching on Quindarius Zachary for buying guns for everyone in YSL, but I can't understand a single f***ing thing.
So what if y'all find stolen gun? Y'all still sell it to him? You just tell me 30 or something? Nah, you found it out. He bought a stolen gun, a Jeep gun. If I call you right now, I got something to get back. Man, buy everything.
He buys whatever. He'll buy a stolen gun, a legit gun, I think he said, and he'll buy everything. Quindarius Zachary isn't even charged in this indictment, so...
And so this is not him speculating. This is him talking about purchasing guns. Again, both Quindarius Zachary and Mr. Copeland are members of the larger gang, which is YSL. And the fact that they purchased guns is part of the overarching larger gang conspiracy.
Have you already asked Mr. Copeland already about guns and the purchase of guns on in your direct thus far?
I don't recall if I've asked him about guns. So this is not him making it all up. As he said in court, that everything he said, he just telling him whatever it is that he wanted to say. He's not making this information up. And so
why would you think that it could be played before you ask the witness the foundational questions?
The reason why this video can come in.
I'm only gonna let you go so far. Okay. I mean, I think you've got to ask some questions in regard to that. I mean, if they haven't been asked, I'm not saying you can't ask. If you haven't asked them already about this, there's some foundation that needs to be played. All right, I'm not inclined to let you impeach him by contradiction at this point because because he hasn't testified about anything about any guns or anything like that, and you haven't asked him anything about any guns, which we just said. So if you had asked him about guns and then coupled with the potential not being truthful, you could probably at that point in time the foundation would probably be satisfied. I'm gonna exclude it at this point in time, Ms. Adams.
Look at her face. She was smiling like she's like, why didn't I ask him about guns on direct already?
How you hook up with Thug and them. Mr. Copeland goes on to say, he wanted some weed, he says a zip of gas. I just blended in and then started kicking with him. And I just knew the people who got Percocet and stuff like that, I used to just go take it to him. Number one, not relevant. My point is, we've got an indictment, we've got an allegation of a conspiracy, and keep adding to the conspiracy by saying, well, there's something in the transcript or conversation that talks about him buying Percocet or him buying weed. And so that's part and parcel of the overall conspiracy. It's simply not. There's some things that are just not relevant. I don't believe that, whether or not Mr. Copeland observed Mr. Williams, whether it's true or not, buying or smoking marijuana or buying or ingesting lean or Percocet, that's relevant to any issue in the case. It's certainly not relevant to anything that's charged. No specific indicted offenses, no acts of the conspiracy. So I think it's irrelevant. And I also think it goes to character.
Yeah, I was just about to say that fucks up Thug's character. Showing the jury that he does drugs. I mean, common sense says a rapper does drugs, but Thug is only charged with RICO. There's zero correlation to drugs.
Mr. Williams' character to insert that in the trial, it is certainly more prejudicial than probative. It's not probative of anything, quite frankly. No issue that's before the court or before the jury. And so I would ask that be kept out. I simply don't think that it's relevant. If they're attempting to impeach him, kind of pick and choose what you're impeaching him for. And you don't just get carte blanche because at one point he either says, I made that up, because he also said, yeah, I probably said that. You don't get to say we're going to impeach him by just playing everything, and every single thing in his statement is relevant and comes in and is not subject to any other objection. So
the challenge you have is you've got to still ask the question about that area. And then I think it picks up from there until you lay a little more foundations for that reason. I'm not saying you can't play it, but you still have to give that witness an opportunity to be heard on that particular thing, asking about the gun, asking about that. So
the fact that he says, I made it all up, relieves the state from having to go line by line and asking about specific statements.
I don't have any issue with that. I don't. But I still think you guys, it's not like you have to give the witness an opportunity to confirm or deny. I'm not saying that. But I think as a matter of, you've got to orient the witness and tell him and ask him questions about the gun. You can't impeach him on a gun when you haven't even asked him anything about that. He hasn't even said, I don't remember anything about it. So, I mean, I think you need to introduce the topic. And then if he says, I don't remember, I don't recall, then you can do that.
Usually the judge ride or dies with case law. He loves case law. This time he's just like, that case law, you even asked him shit about this topic of the gun, so.
What Mr. Copeland tells the detectives back in 2015 is that this relationship kind of grew. It grew from possibly him being the person who facilitated giving him drugs to a more developed relationship, which was not just a fan. We have pictures of Mr. Copeland and Mr. Williams at each other's homes. Oh, I met Mr. Williams at the studio, and I was a fan of his.
Woody lied so much. Woody was acting like he was a fan of Thug.
So, Your Honor, again, we have charged in this indictment the fact that the members of YSL possess and sell and distribute narcotics. So this talks about that relationship. So this is relevant. This is already in the indictment. This is in the preamble of our indictment, Your Honor. So I believe that the jury understanding the development of their relationship is important to assess whether or not they find what Mr. Copeland is saying in his 2015 interview credible. Prejudicial, substantially more prejudicial and probative, because there's already evidence before this jury of Mr. Williams being in and around or associated with narcotics, Your Honor.
But not him doing it. Not someone talking about him taking perks and shit. He was around it. Keith Adams looking good in his light blue suit, right? Bro looking clean.
Them either smoking weed together or him getting some weed from Mr. Williams or some lean or some Percocet. And my position is that is irrelevant. That it doesn't go to any issue in the case. The fact that the indictment alleges that members of what they say is a gang were selling or engaging in the sale of narcotics is separate and apart from whether or not someone's smoking weed together. Right? I mean, just keeping it that simple. I'll do what Ms. Hilton has done. To put it into context, there's more in the transcript and in the statement that actually addresses that. If you continue to read over the next page or two in the transcript, you see Mr. Copeland saying, after a while, every time I go up there, he had me chill for a little minute and stuff. I never just go up there and then leave. He says chill or something. We carry over to the next page where Mr. Copeland says, and then after that, just started hanging with him. You know what I mean? Started putting my name in his songs and stuff, just like, oh man. Then we started hanging a lot. In his statement that describes exactly what the state says they're looking for, how the relationship developed, what was the nature of their relationship, without us necessarily having to inject this character evidence about them smoking weed together or getting lean or getting Percocet into the trial. It's simply not a relevant issue. I think it's irrelevant. I think it injects his character improperly, and I think for that reason. And I also think that what they're looking for is contained in other unobjectionable portions of the statement.
I mean, it's up to the jury to determine whether or not it's relevant, but I mean, I'll make a threshold determination, but whether or not it goes to anything.
Right.
What would you say if I just said, well, it could be potentially admissible, if just to show possession of illegal substances by YSL members, purported YSL members. But they have to first make that determination, and then of course, what it'd be used for.
If they want to allege that Mr. Copeland and Mr. Williams smoking weed together at the studio is an act that is part of the overall conspiracy, then they allege it in there. But they haven't done that.
The YSL organization uses criminal activities to expand their criminal networks. So the fact that Woody started off as a drug dealer, this isn't about them smoking weed in the studio. What it was is that he was bringing him the drugs. That the fact that he started off as a drug dealer and then was able to get into gang itself or the organization and become an associate is a parcel of the larger RICO conspiracy.
It's fine for them to have a theory, right? But just because they interpret it as such doesn't mean that there is evidence of that. You can't say that, well, him saying that we smoke weed together in the studio is evidence of him bringing him into a gang and him engaging in conspiratorial conduct.
Look at the judge face palming, thinking this through.
Court had an opportunity to review the indictment in this case and also consider the arguments of counsel. I'm in concurrence with the defense that it is not relevant for that particular purpose. It shows more the individual use, or more so than it does indicate in the preamble to the indictment that for the possession, sale, or distribution of obtaining money, weapons, or other property through acts of racketeering, including robbery, theft, and unlawful sale and distribution of.
So Mr. Copeland starts line 23 saying somehow Thug's daddy, Thug's daddy, he did with Kente and them a lot. Thug's daddy told me out his own mouth, like he's connected.
Hold on, anything Thug's daddy is saying ain't relevant.
And so for no other reason other than that it's hearsay, that's relevant. I'd actually be distracted or excluded.
He says, I didn't want to tell them about my so-called friends at the time. But in the way he was saying, like, I talked to the police a lot. You know what I mean? Like, he knew I wasn't going to tell, but he knew I was talking to him. So I don't know how he gets his information. But when he said that, I thought he was just talking at the moment, trying to scare me up or whatever. And so I think that is the most salient line, is that we're not offering it for the truth of the matter asserted, which is whether or not Mr. Williams' father has connections in the street, whether or not Mr. Williams, that's how he gets his information. But the effect on Mr. Copeland's state of mind and the effect on him as the listener, hearing whatever it is that Mr. Williams was saying to him, that's how he interpreted whether or not people knew he was talking to the police and what he was disclosing to the police.
And the truth is, it is being offered for, the state wants it in for the truth of the matter asserted. But it doesn't really go to anything. It's just his opinion.
Your Honor, but that's the key point right there. It is what Mr. Copeland thought as to why he is concerned about people finding out if he snitched or not.
They want the jury to know that Mr. Copeland is concerned about his name being out there or him being labeled a snitch or that he is talking to law enforcement, then it's cumulative because they've already got that. There's already been testimony. I think the jury's already seen.
I think the jury's seen Woody snitch about 100 fucking times.
You know, so there's been testimony about it. You've already let that in. What we're talking about here is hearsay. Something that Mr. Williams' father purportedly said to Mr. Copeland.
And you might understand that Mr. Adams keeps saying it's hearsay. It is not. And the fact of the matter is, it's not cumulative. The fact that, and especially in this part of the interview, he is telling a different set of detectives this information. He's actually talking to some IA detectives about, they get to see that his biggest concern was being labeled a snitch. That was one of his biggest concerns in this interview.
I understand that, Ms. I do. I just don't think that this particular section drives home that point. I do agree with Mr. Adams. I think that it's cumulative and it's...
I really didn't anticipate the judge to switch back in favor of the defense there.
Again, if somebody opens the door up as to it and lays a foundation as to it, then I may revisit my decision on that, okay?
All right, that's it for day 98. Let's go on to day 99. We're really close to 100. Wow. First look at Thug on day 99. Brown sweater on today, looking down. So I guess these boys are just allowed to have headphones in and like watch videos and chill while their lawyers handle everything.
They haven't laid the foundation by asking him any questions so that they can now go into it and just carte blanche play what he says. Because what happens then, if you allow this, is they're playing the video, and especially the testimony is coming out based on this audiovisual interview, as opposed to him testifying about it and either admitting or denying that this is what he knows. Foundation, first and foremost. And then the other things that I've indicated, hearsay, inability to confront the witnesses that he says he gets this information from who.
Do you remember where you picked Little D up? Where did you pick him up at? McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to McDonald's on Cleveland Avenue, was there anyone else with Little D? Just him and Shannon. Anybody else? Just him and Shannon. When you pick up Little D, what did Shannon do? What do you mean? You said you picked Little D up. Did you also pick up Shannon? I said I picked them both up. When you picked up both of them, where did y'all go? I blanked out after that. He does not remember anything that happened in the car, which would be the conversations that he had with Little D.
And this is when apparently Lil D told him that they just killed Peanut when they got in the car. Or at least Shannon just killed Peanut.
Told the detective that Nard was in the car with him. And I believe that I asked him further on, and we don't have this part of the transcript, did Nard ever get in the car with you? And he says, no. So, Your Honor, we have confronted him as it relates to what occurred, and we have laid a foundation to introduce that because we've asked Mr. Copeland here in court, what did you all talk, or did you all talk about the murder when the three of you got in the car? And he says no.
God damn, Woody's a snitch. His boys got in the car and told him some shit like that, and he told the detectives that. Or he's lying, and he's the one that killed Peanut. There's a lot of people out there in the comment sections and my Instagram DMs saying that they believe Woody killed him, so.
This is based upon what the Mikian told you. And he says, yeah. So again, this is the co-conspirator hearsay. Mr. Copeland has just reiterated Bentley's role in the murder of Donovan Thomas, that he is the place where both the car gets disposed of as well as the guns get disposed of. And so what he is saying to the police is, Bentley and I have now fallen out. Bentley and I are no longer friends.
I actually understand what the state has been saying about this effect on the listener situation.
It's telling this woman about wanting to kill me when he knows I had nothing to do with this murder. And so we're not offering it for the truth of the matter asserted as to whether or not Bentley actually said, if you feel like he killed your brother, just let me know. One call that is on. It is the effect that that had on Mr. Copeland, and in turn, what he does with the information.
I still don't think that there's been specific enough questions asked of him on direct such that what would be played in this would be impeachment by contradiction.
The court is of the opinion that based upon what the court has heard from direct testimony, that in his direct, he says he doesn't remember what happened in the car. The state has asked a predicate foundation to explore from Mr. Copeland impeachment, at least impeachment by contradiction or prior inconsistent statement. So I'm going to omit those and allow the state to play that portion of the tape over a defense objection.
We want this stuff to stop. If y'all were just making music, he says, I like rap music. I like some of Thug's music every now and then. Copeland says, yeah, but that ain't what's going on. That's a fake card, all this other stuff. And then Copeland says, it didn't start until we got with Thug. This line is in direct contradiction to the defense's assertion in opening that the focus of their investigation was all about Young Thug and his music. That we attacked, as the state, as the police officers, that we were only focused on using these lyrics and this music, and then we created a case solely based off of the music. And this is in direct contradiction to that. In the course of the investigation, the investigator Dennis, is telling Mr. Copeland, this is not even about the music. Matter of fact, I like some of his music. This is about what has been happening in these streets, what the shootings that have been going back and forth for now, at this point, 6 months, and encouraging Copeland to continue to tell the truth about what has happened. But no, they were focused on stopping crime and it had nothing to do with the music.
Defense doesn't want detectives talking about the music, saying it's not about the music, it's about all the shootings going on.
This is the detective's opinion, what the music is or is not. So for example, if you look at line 19, when he says, but that ain't what's going on, that's a fake card for all this other stuff. If that's the case, then let's prove it with evidence as opposed to giving the jury the detective's opinion as to what that is. Because without more, what the jury ends up getting is the detective's soliloquy on what he thinks the music means, whether or not it's being propagated for art, or whether or not it has something indeed to do with the rest of the case or any of the criminal activities that are being that have been indicted. I don't think number one, his opinion is not relevant in regards to this item of evidence. And I think there's a fair amount of speculation on the state's part. Again, I've said it before. I understand they have their theory, but when Madam Prosecutor says that Mr. Copeland's response, it didn't on line 22, it didn't start until we got thugged. When she opines, well, when he says we, he means Shannon and Demekian, and this is who he means. Well, there's no, they don't know that. They don't know that any more than we do, unless Mr. Copeland gets on the stand and says, hey, this is what I meant. And this is what I'm talking about.
Yeah, they are kind of inferring who he's talking about.
So that part is just speculation. But these few lines that we're talking about is nothing other than the detective's speculation as to what he thinks the music is, his opinion.
You know, the state is making the argument that this out-of-court statement should be played because of arguments some defense counsel made during opening statements. My recollection is that certainly that Investigator Dennis has been on the stand. He provided live testimony rebutting the defense argument about following lyrics and instead said, no, we follow crime and then found lyrics. I believe that was Dennis. It may have been Gates. Anyways, the state has provided live testimony regarding that issue and their counter to whatever was argued in opening that they say was argued in opening. So I don't know why we would allow out-of-court statements, hearsay statements that also have problematic parts in speculation, as Mr. Adams has stated.
Which is impeachment by contradiction, is an adopted admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis.
The court is of the opinion that it is opinion by Detective Dennis and it is speculation, so I'm going to exclude it.
The judge today has been wildly in favor of the defense because there is a lot of hearsay and shit that shouldn't be in the trial. It's just a waste of time.
Detective Thorpe is speaking, and he says, so let me ask you this. Of all of them, who do you think the first person I should go after? Ms. Copeland responds, to lock up or to talk to? I would say do-up, but if you go after him first, they're going to have a feeling somebody told. You feel me? That's an opinion.
Bro, Woody's basically a detective. Like, this man Woody was helping them with strategy on who to go after first.
I should go after first. Mr. Copeland says, truth be told, I want to say Shannon. Feel me? Because when he got locked up, Shannon looked like he wanted to tell. You know what I mean? Tell on them. Again, an opinion, speculation on the part of Mr. Copeland. Detective 1, yeah, but that was years ago. How you feel about little D? Like, since D was the one that supposedly wasn't shooting, but he came and told you, Ms. Copeland says, D thinks he's hard. It's his opinion. Detective 1, so he probably wouldn't just because he thinks he's hard. Speculation as to who might talk or who might not, regardless of what he knows about those individuals, is in fact speculation, it's opinion, and it's not relevant.
And what this shows is that the detectives were trying to speak to other individuals in order to corroborate what Copeland told them. And so they are asking Mr. Copeland on who out of these individuals he should talk to. So I know we keep throwing around the word speculation and opinion, but a lay witness can give their opinion. That opinion is rationally based on the perception of the witness, which is 24-7-701.
Did you ask Mr. Copeland about this on direct already?
Asked Mr. Copeland
about any of his discussions with Detective Dennis in regards to this part of the investigation. I don't recall it being asked.
About if he told the detectives who he should speak with in regarding this case. No, I don't believe I asked him directly that specific question.
I'm gonna exclude it for foundation right now. I'm not saying it may not be admissible.
I'm so surprised the judge has been doing this today. The state keeps trying to get into shit that they haven't laid foundation for specific topics. And the judge is like holding strong on that.
I don't recall. I don't remember. I think you still got it, as I mentioned to you yesterday. With all due respect, you still got it since you haven't asked him about it yet. It wouldn't be proper to just play this.
Shannon shot a Lil Wayne's tour bus. Shannon shot Nut. Shannon does whatever Thug says. So anything that D told him, that he told police D told him, would be impeachment by prior inconsistent statement, impeachment by contradiction. He said, I made it up to clear myself, and that's it.
Sure?
That's not true. The state's skipping a step. It's first of all, impeachment by contradiction.
No, it's anything that the witness testifies inconsistently with earlier. I mean,
respectfully, that's what prior inconsistent statements are.
It can be.
Contradiction, Your Honor, is witness named Jeff says the light was red at the time of the crash. You bring in witness Brian that says no, the light was actually green at the time of the crash. That's impeachment by contradiction. You bring in another witness to testify about how the first witness was incorrect or wrong or contradictory. Prior inconsistent statements is a type of impeachment contradiction using a witness's prior statements. What the state is missing here is they're saying, was Demekian in the car? Did Demekian say anything? Kenneth Copeland is saying no. But that's not the correct question to lay the foundation for prior inconsistent statements. They need to say very specifically, they need to ask, did you tell police that Demekian Garlington told you this on this date? That lays the foundation. And they're also confusing the issue by including Shannon in these conversations, which has never been said. And if he says yes, then they don't get to get in these prior statements because they're not inconsistent. The question.
Miss Love is shaking her head. She don't agree.
You're right, but that's the point, Your Honor. We agree. He never told the police that Shannon was in the car. So he is contradicted by what he told the police previously. And he said, I don't have to ask him again. His answer was, I told you and them that what I told investigators when Nut got killed, something different because I was trying to finesse my way out of the situation. He has already admitted right there that what I said to the detectives in 2015 is a lie. It's not true. I finessed my way. And it's inconsistent with what he is now saying and what he said back then.
This is such a cluster. It's actually very confusing.
Or I'm going to admit or allow the state to play that particular portion from.
I get what the state's arguing about the killed now, but those other statements, they're just bad character, generalizations, not inconsistent with anything he's testified to on the stand, not inconsistent with anything that he's been confronted with on the stand.
It's the respectfully, it's the conversation in the car. The jury decides whether or not they believe it or not, whether or not the version that they believe was the one that was done on the 10th of January of 2015, or on the stand, or on or about.
Obviously, the jury saw what he says on the stand and what he says in the interview, and let the jury decide on what they believe. And this is their star witness. It just doesn't seem like it's a good argument.
We have charged Mr. Williams with a leadership charge. So this directly goes to the fact that anything that the leader says, Shannon does. So that directly addresses the leadership charge that we have charged Mr. Williams with in this indictment. Furthermore, Your Honor, again, when Mr. Copeland has said everything that I told investigators regarding the night of the murder, regarding anything I told them, I was telling them anything to finesse my way out of going to jail. This will be in contradiction because he's saying, but it is important because we have charged Mr. Williams with the leadership gang count in this indictment.
It's all speculation. And I understand that the state feels it's relevant because they've named that Mr. Williams, they've asserted that Mr. Williams is somehow a puppet master over everyone, which isn't true. But
Right, SCHARDT is so funny sometimes.
just because they've asserted it doesn't mean all types of everything is admissible. It still has to be based on personal knowledge. It can't be speculation. And so, yes, they're asserting, okay, it's relevant because this is the way we charge the case, but that doesn't solve all the other evidentiary issues. We're not even talking about something that the man's saying on the stand. We're talking about it being played in a tape, out-of-court statements. Doesn't mean they just get to play a bunch of tapes that fit their narrative.
Low-key a good point from SCHARDT. She basically just said that it was because of the way they charged Thug that this should come in. Because it shows that Thug was the leader and they were all puppets or whatever.
I'm still going to admit it for its purpose. Over your objection, I'll give you a continuing objection, sir, to that respect.
All right, Brian Steele's upset about something. Here we go.
Mr. Copeland is asking for a lawyer. I believe the state alleges that he's speaking with Mr. Jeffrey Williams for part of that call at about that time.
This is about jail calls. Woody has jail calls.
Uses my name, my first name on the call. I would object and ask to redact that portion, especially my name.
And listen, I don't believe he said Brian.
So Steele doesn't like his name being mentioned in front of the jury on a jail call with Woody and Thug.
I was just gave him a lawyer, 3-4 band, $25. You know, he'll bring you.
You have 1 minute left.
They get you in the courtroom for $25. You know, that ain't shit.
I don't even want that much. One lawyer had told
I know.
I might have this son text you my information because you said you try to in the morning.
I had a lawyer, or whatever lawyer you choose.
I don't have none.
Well, I could just have somebody pull up on Deshaun and bring Deshaun the money then, or Deshaun my daddy, because, you know, they probably know something about the shit.
So Thug's trying to help him get a lawyer for some sort of probation case or something, I think.
Shit, we don't know no lawyer though.
Yeah, you know what I'm saying? You know my lawyer.
So
I know I ain't got the number to hit him.
You
Just tell him, he already got my card and everything. He already got my card in his system and shit, so I ain't got the number to hit him.
Thank you for using Securus. Goodbye.
Cuts him off like that. Bro, jail calls are crazy.
Brian or Mr. Steele's name at all.
You know what I'm saying? You know my lawyer.
So you
I know I ain't got the number to hit him. Just tell him, he already got
He just said, I know Brian. Thug just mouthed the words, I know Brian.
my card and everything. He already got my card in his system and shit, so I got the number to hit him.
You can stop it.
Okay, don't get the number right here. And
That's fine. We can stop it right before.
But what if they don't stop it? They've done that in the past where they don't stop it in time.
I don't know the relevance, and then it gets cut off. So I'm objecting to that.
Bro, Steele is such a good lawyer. Well, I don't know the relevance.
To the relevance of, you know, my lawyer.
Yeah.
Or that part of the tape?
What difference does that?
Okay. State?
We believe that as a part of the RICO conspiracy, the fact that the leader is offering up his lawyer to pay for another co-conspirator to gang to get out of jail is relevant information.
Oh my God, the state reaches so hard, bro. This is not the Sopranos or Mafia movie, dude. This is a friend on the phone with another friend, like, you know my lawyer, and this one friend has money and has a lawyer. If you were filthy rich and your friend was in jail and needed a lawyer, would you help your friend and give him a lawyer if you were like that close of a friend with them? Probably.
Who it is, that's fine. But the fact that he's offering up his lawyer for another co-conspirator is relevant.
Can Steele, anything else?
It was a conversation that got cut off. If you look at the records, or if the state bothers to look at the records, I did not have anything to do with Mr. Copeland ever.
He was never even Woody's lawyer. So just the fact that Thug offered it and it never even came to fruition. Apparently that's a big gang mafia.
Represented Mr. Copeland, so I believe that he's irrelevant. Just a conversation that was then cut off. So you don't get the entirety of it.
That will go to weight, not admissibility. He can surely ask, if he chooses to ask Mr. Copeland any questions, did you ever get a lawyer? So he can ask Mr. Copeland that question.
Mr. Steele, anything else before I rule?
I just don't think it's needed to say my lawyer. That's what I'm objecting to. I don't mind the conversation about I need a lawyer. I think Mr. Williams says get any lawyer you want, something to that effect. That's not a quote. But I don't see the need to say I have my lawyer, I have his business card, I can call my lawyer. I don't see how that is relevant. And then it gets cut off. So I don't know if that means the state is saying is, oh, and then he's going to get Mr. Williams, personal lawyer for Mr. Copeland. That's not what it says.
And that would be certainly speculation.
That
would be speculation, but I think they get at least to play, based upon what they proffered so far, I think they get to play it. It's subject, and also it's very limited as to what it can be said about it.
You know, they're discussing, I need money for a lawyer. I don't know any lawyer. A statement is made, we'll get any lawyer you want, and then just end it there.
Your Honor, relevant evidence is any evidence that tends to prove an issue. We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy. So we believe that that is relevant, because the argument is relevant. It also comes in because...
Can we just see some phone tracking and some DNA and some like ballistics of these guys committing crimes? That's all I want to see. We've seen very little of all of that.
The party opponent admission. This is the defendant Williams telling Mr. Copeland, and he said, you can call my lawyer, is what he actually says. So I think reading it in context, he's saying, okay, you don't know any, but I'll provide mine, or you can potentially use mine.
Maybe because he's a friend. Isn't that crazy? Rappers can't even help their friends anymore with lawyers.
Whether or not he used him or not, that is a question that can be asked of Mr. Copeland. But the fact that he was willing to offer up the lawyer is what is important, not the result of it.
This is a very bad point in our community if we are now going to say, offering to get someone a lawyer part of a RICO conspiracy. This is a probation revocation case on supposed non-compliance with community service.
Wait, he's in jail because he didn't do community service? He didn't even commit a violent crime or charges or anything.
That's what it's about. Mr. Copeland says, and it basically mirrors what he said on the witness stand, is to then say that it's part of a conspiracy to get a lawyer for someone going to court on a probation revocation case, I think is a bridge too far. To say you're going to get a lawyer, I don't have a problem with that. But to say I offered up my lawyer because that is symbolic of a crime, it seems to me that if that type of evidence comes in court, we are all in trouble, because that's what we want people to do. We want people to get lawyers. So I'm objecting to the state's playing that portion. I'm not objecting to the portion that Mr. Williams allegedly is on the phone and is offering to potentially help with a lawyer. I don't have a problem with that. If the state wants to then argue that's somehow part of a conspiracy, I'll argue against it. But to then go further and say, aha, and this is a crime organization and the lawyers are part of the criminal activity, I think that is under 403. It should never be said in any courtroom unless there's proof of it.
Your Honor, the state never said, I don't even know where Mr. Steele got that last assertion from. The state said what is relevant is that he was willing to offer up his attorney to represent him. That is where it ends. And everything else Mr. Steele said is great for closing argument. But the relevance of it comes in, and then he can argue all of that, what he just said in closing.
It's relevant. It's more probative than prejudicial under 403, and I'm going to go ahead and I'll allow it. I'll give you a continuing objection, Mr. Steele, in that respect.
What was that interaction? Brian Steele did this or something. All right, that's pretty much it for days 98 and 99. Not too interesting, but we heard that jail call with Thug and Woody. 80% of it I couldn't understand, but basically Thug was offering up Brian Steele. Steele didn't like that. No more court for the rest of the week. I don't even think there's court on Monday either. It resumes Tuesday with more jail calls. Comment down below what you guys think. Hit subscribe. Love you guys. Peace out.